The case for oral argument this morning is Rebecca Sink versus John Williams, case number 28970. Morning, gentlemen.
Morning, Your Honor.
Morning, Your Honor.
Each party will have 15 minutes to present their arguments. Appellant may reserve up to 5 minutes for rebuttal. Just let me know how much you would like to reserve, and I'll keep track of that for you once I get this reset. Okay. Arguments are being recorded and they will be posted on the court's YouTube channel, so please keep your voice up and remain behind the podium. I'm trying to remember, did this case involve minor children?
It did not.
Okay, I didn't think so. All right, we ready for briefs and are ready to proceed when you are, sir.
Thank you, Jones. I reserve 5 minutes, please.
Yes, sir.
Your Honor, obviously you've had an opportunity to read, obviously, the briefs that were written, so the court is aware that this is an appeal from the Summit County Domestic Relations Court regarding a ruling issuing a civil protection order. The lower court found that a civil protection order was appropriate to be issued under the menacing by stalking, and found that, therefore, the evidence was supported that. Obviously, our brief and our objection is that the court abused its discretion and the manifest weight does not support that decision. Your Honors, basically what we're here for you today to decide is this court going to approve that non-threatening behavior can be appropriate evidence for a representation of being put in fear without any kind of review of whether that representation is reasonable. Obviously, with looking at the transcript, we know that my client engaged in a volume of emails to the petitioner in this matter. But what we also know from the evidence that was presented, that there is no threats contained in any of those emails. There's no threats contained in any of the texts. We had 2 officers take the stand that were called by the petitioner, both of which admitted that they reviewed all the evidence, which was the same evidence that the court was presented, and found that there was no threat of any manner whatsoever. That's why no charge incorporating a theft criminally was levied against my client. There was no domestic violence by threatening, no menacing, no aggravated menacing. So what we have is a volume, a pattern, that's fine, of non-threatening behavior, benign behavior, of which the client, or excuse me, what the petitioner represented as having an effect on her to establish the mental distress issue, and the mental distress component that's required to be found. Well,
Is that a subjective test, so?
Well, there's reasonableness that needs to come into play with that. And what it is everything can be subjective, but is it reasonably subjective? I can look at you and tell you I'm afraid of that clock, and I can sit in a witness stand and tell you that clock absolutely impacts upon me mental distress. Well, I'm allowed to think that, but is that reasonable? Because what we have now is we're taking into consideration the issuing of a CPO. And without engaging in too much flowery language, that's a sword that when issued cuts a wide berth. It has impacts upon the individual that is then the subject of the CPO that restricts his liberty, exposes him to further criminal liability, and what we're allowing is one to be issued on a representation that repetitive, non-threatening behavior caused me mental distress, and then deciding, is that reasonable? Is that reasonable for the consequences and for the totality of the circumstances, to the extent that the court did not abuse its discretion, to the extent that it was not great, that it was not the manifest weight.
Part of they had then was this pattern of conduct of emails and texts.
That would be correct. There was testimony about, well, they saw a car that looked like his at a bar. Well, even the magistrate that interjected and asked questions Nobody could say it was his car. The petitioner had been in that car, couldn't identify the license plate. The best that could be said was, it was a car that looked like his, and they even admitted, the witness even admitted that it was parked, it's in a plaza. The car was parked closer to a grocery store than the bar that the petitioner was in that night. Nobody saw the petitioner in the bar, or excuse me, the petitioner and none of the witnesses saw the respondent in the bar. So we have these things, but then we have a car that might be my client's car, but they never saw him. There's an issue of maybe she saw him at a park, but they had no contact. Well, it's a public park. He's allowed to go wherever he wants. It actually belies and contradicts the argument. If this is an individual that's so repetitive in his attempt to contact you, they send you multiple emails and texts throughout the day, yet happens to see you in an area but does not confront him, does not confront her. Again, it's benign happenstance behavior that the respondent was. She took the stand. She almost cried. The police officer said, absolutely, she came and she was very distraught. Well, anybody can say they're distraught. Is it reasonable that she's distraught and exhibiting mental distress over non-threatening behavior? Is it reasonable to the extent that it rises to the level of which a CPO is appropriate?
What about the fact that he ended up contacting the softball coach and wanted to coach her daughter's team and wanted to buy a uniform?
Well, I don't think that's correct. He didn't want to coach, he wanted to sponsor. And he's done that, and people have done that all the time. As a matter of fact, that individual took the stand and said he didn't find anything wrong with that. People offer to sponsor all the time.
Well, but he went to the petitioner here and told her about it.
Absolutely, because
he was worried about it.
oh no, I don't believe that's correct. I don't think the word worried is just because he knew that they knew each other. It would be something that would come up in conversation. I don't think the word worry or concern would be inappropriate.
Well, that's how I'm surmising it, but maybe I'm misspeaking or maybe I'm missurmising it. But anyway, the point is, he made sure that he told the petitioner about the fact that he had contacted
Sure,
the
because
softball team to sponsor as well as to buy her daughter's uniform.
Sure, because my client, again, hi, I'm calling, I know this girl, I would like to sponsor her team and or any other team, and I'm willing to buy uniforms.
Did he say willing to buy uniforms or willing to buy a daughter's
Well,
uniform?
No, uniforms, not specifically her and only her. That's not correct. So when he makes that statement, of course that individual said, hey, this guy's coming to sponsor, he says he knows you or your daughter, and he's looking to sponsor. Those are the kind of conversations that are had. It was not, that individual did not give any testimony that he conferred that to the petitioner out of concern or care or worry. Again, he even said he had no problem or care or concern with my client wanting to do such a thing. People that do not have children that play in those leagues sponsor teams all the time.
What about the testimony that is unusual for somebody that didn't have children?
I don't think that was the
It's in
testimony.
the briefs, I don't know. I'm just
I
saying
don't,
what I read.
I don't believe that,
Because there was some allegation that he wanted to coach because they said that was unusual for a non-parent to want to coach.
that is unusual for a non-parent to want to coach because in the world we're living in, not a lot of people want to give up their time unless they have a vested interest like their child is playing. That's correct. I would agree with the aspect of coaching. It is unusual because most times what we have are parents. Those are the only people that are willing to carve out 4 to 6 hours a week to coach a youth sports team.
So you're saying that there was no evidence that he specifically asked the coach?
Yes. I think it was merely.
Yes, there was evidence.
No, I'm saying there wasn't. I
That's
think it was sponsor and or purchase uniforms. Again, even if he did, I mean, we're getting to the point where the consideration is a judgment entry affirming that, again, that's not a threat.
I don't think the case law says it has to be a threat, because that's the whole point of mental distress, right?
Well, then we're going to allow anything to provide mental distress. If I can corroborate 2 or more events, whatever they are, and I subjectively say that's mental distress, and I sit up on a stand and I cry, then I'm getting a CPO issue. I think that's a very low threshold. I think there has to be some understanding of reasonableness as to my representation of mental stress.
Well, what,
In your,
go ahead.
the situation that Judge Carter described, I thought the testimony was from the director of the league or whoever he approached to talk about the uniform. When he talked to Ms. Sink about that situation, he testified that she started crying and shaking.
Absolutely, she did. None of that's, I agree. She exhibited mental distress. She exhibited mental distress while she testified. She exhibited mental distress to the police officers. That's what they testified to. I don't find them to be non-truthful. This individual from the Little League Baseball, or excuse me, softball league, stated that she exhibited mental distress when he spoke. I don't find him to be untruthful. Is it
calling
reasonable?
the police in and of itself evidence of mental distress?
I'm sorry?
Isn't the fact that she had to call police in and of itself evidence of mental distress?
I don't believe that. I think there's a lot of evidence of mental distress. I'm asking, is it reasonable that she has the mental distress? I can think that clock is intimidating to me. I can call the police on whoever logistically hangs things in here and say, that person that hung that clock there did it to me because he knew I don't like that angle. And that's causing me mental distress. Anybody can call the police. Is it reasonable that these things, these non-threatening, non-violent communication attempts would create such a response? And again, if you look through the record and the transcripts as well, she responded to him as well. She responded to him twice. None of which did she ever respond, hey, stop talking to me. This is getting, I don't like it. You're intimidating me. She never expressed to him either to stop, and she did not express to him how this is impacting her. So in a way, it also attacks the knowingly part of his behavior. He's not knowing that, even though it's not his intent to do something, to have this impact, he's not knowing it is having this impact. She responded in one text, thank you, something about tires, thank you for checking up. And again, one of her other responses, because she had two that were within, again, memorialized through electronic communication, none of which were, again, stop talking to me, stop contacting me. You're not making me, I'm getting intimidated, I'm getting worse, this is getting out of control. None of those things were communicated in any way, shape, or form. And she had more than an opportunity to do so.
Well, if he knew, I know he's on if he knew that, if he didn't know that she didn't want to talk to him, why was he sending emails under a fictitious name?
Well, I think that's sometimes just an emotional immaturity that in relationships that aren't the most positive, as we all know that these were, which was laid out in their need to establish cohabitation. This is a relationship and an association that languished over time, ups and downs, and it's part of maybe not the most positive and emotionally mature relationship. But again, outside of that, is it, not something you would do? I understand that, but that's not a threat.
3 minutes.
Thank you.
Good morning.
Morning, may it please the court. My name is Attorney Robert Bismarck here for the appellee Rebecca Sink. I appreciate counsel's position. I suppose I'm not too proud to say this, but in recent time I've walked through the grocery store checkout and I see some of my favorite magazines, Us Weekly, and on those covers are our Taylor Swifts, our Kim Kardashians, and I suppose back in my day maybe Jennifer Lawrence. Appellant's position is that my client, Ms. Sink, was unreasonable in having this fear because there were no outward threats. I think the statute, Your Honors, is clear that these outward threats are unnecessary. I think the case law is clear that threatening language isn't necessary. I reference our sort of pop stars these days because I read in these magazines that similar situations occur to them, where a crazed fan shows nothing but admiration and desire for those people. Letters, emails, attempts to contact them are being sent through numerous mediums, and ultimately, those letters of admiration can rise to the level of fear. Here, it appears that there's some concessions based on some of the briefs, and maybe not concessions, but I think that there's undoubtedly that our two parties cohabitated together. I think that regardless of my supplementation of some of the case law, I believe that under State v. Williams there was enough in the record to indicate cohabitation. The exhibits that were approved indicate, or that were admitted indicate that they not only lived together, that he bought this house for her. She was getting mail at the house. There's anecdotal evidence in which the children are residing together. There's a reference that he bought this house so the kids could go to school together. So I believe that that threshold has been met under State v. Williams, but subsequently, and my apologies to this court, I should have cited the clarification by the Supreme Court and subsequent following of that case law in our 9th District case, State v. Cornwell, in which it said, State v. Williams refers to a case where the two parties were going together, and if the two parties are in fact cohabitating, you don't need to go that far and show cohabitation, even though I believe we've met that burden here today.
Counsel, did you say that you hadn't cited that in your brief?
In the original brief I had not. I filed a supplemental authority brief, just attaching the two cases, the Supreme Court case of McLaughlin and the 9th District case, State v. Cornwell. I think there's a consensus that we've established a pattern of conduct here. The emails began immediately after the termination of the original civil protection order on October 13th, 2017. There are multiple emails, multiple text messages. I think it's undoubted that this, quote, pattern of conduct has occurred. So the real question is mental distress. And it appears, based on appellant's own argument here, that there's more than evidence that she suffered mental distress. The testimony from Mr. Gardner, our softball coach, indicates that she began to tremble and cry when she referenced it. I have a disagreement with the summary of the testimony of Mr. Gardner. His testimony, and the story arc of this testimony was Mr. Williams reaching out to him in order to coach the team. And he said, well, you can do it on our website. He asked if you have a child on the team. He says no. Mr. Garner testified at no point during his tenure there, which was years, that any individual had requested to be affiliated with the team, coach a team that they didn't have a child on. And then to specifically ask for paying of Miss Sink's child's jersey, I think brings us back to this celebrity obsession argument, that even non-threatening, kind gestures can result in having some mental distress. The officer,
So in the
yes.
celebrity obsession example, I'm assuming that these individuals did not have a prior relationship with the celebrity that they continue to send letters of admiration to. Is there evidence of reciprocal messages going back and forth, or some evidence that this is a continued dialogue even though they have terminated their relationship?
So Mr. Jones is accurate in his representation that there were these two instances in which she had responded to countless emails and text messages. Ms. Sink's testimony was that you don't poke a sleeping bear, so to speak. She tried to be kind. One of them she referenced feeling some sympathy for him as reference to his passing of his mother. And the other was just a brief thank you regarding this checking on her tires. But there is no substantive dialogue between the two parties. And in fact, if there was a categorization of these interactions, it's her simply ignoring him 99% of the time. I think that the emails from Mr. Williams to Ms. Sink actually indicate his knowledge of what effect they might have on her. He makes repeated references to, "I'm trying not to harass you. I called the police and let them know that I'm sending this letter so they don't think I'm harassing you. I can't send any more letters or calls to you, it'll be considered harassment." He understands that he's pushing this line and trying to reach out to her rather. And her testimony about her own mental distress is really all that the court needs to consider. It is not an objective test on whether a reasonable individual under the same or similar circumstances would have the same effect. We actually look at the individual themselves and what impact it had on them. And in Ms. Sink's, it was profound. I mean, aside from having these very difficult interactions in which she's crying and trembling, I mean, she changes her route to work. When she goes to visit her mother, she parks her car on the inside and closes the door so he won't recognize that she's there. She sells her prior vehicle and purchases a new one so she is more hidden in plain sight, so to speak. I think that the trial court, both Magistrate Collins and Judge Cook, were reasonable in their decision. I believe that not only did Ms. Sink suffer mental distress, but assuming if this court believes that there is some reasonable standard that needs to be implemented, I actually think her responses are reasonable. This isn't 1, 2, 5. This is numerous and countless relentless text messages and emails with really deceptive tactics in trying to reach her, creating false email addresses in order to get into contact with her. There was a demonstration at the trial court level about blind copying her on an email he sends to himself that's directed to her. There are numerous attempts to be deceptive in reaching out to her.
Counsel, was there any, I know you said, I think you said that there was no indication, well, she did not specifically tell him, "Don't contact me because she didn't want to poke the bear," she said.
Correct.
What about blocking his?
So there wasn't any testimony that she specifically blocked him. But for all intents and purposes, the ignoring of him is the effect of the block. Whether she did or did not, the lack of responses shows that. And in reference to blocking, even my brief indicates that Mr. Williams sort of puts the onus on her. Listen, if you don't want me to keep reaching out to you, you need to block me all around. Your silence doesn't matter to me. Sending her documentation about the effect of the silent treatment on individuals. I think that, again, if this court should implement a reasonableness standard, I think under the circumstances she was reasonable here. She went to the police, which is evidence through the case law itself of mental distress. The testimony from all the parties involved was that she was not the same sort of outgoing, jovial individual she was. The testimony further indicates that once the ex parte was granted, she sort of breathed this sigh of relief. I mean, if Mr. Williams was to give any credit, I suppose it's in the sense that he did not violate the ex parte, and he continues to not violate it, and as a result, she's been feeling better about herself and able to do the things that she historically had done. In the end, I think that the trial court got it right. They were in the position to witness Ms. Sink on that stand, to really take in her mental distress so that they could see it firsthand. They judged the credibility of her and all the other witnesses. Mr. Williams didn't testify.
Of course, you also got his mens rea that he...
Say that again, Your Honor?
I'm sorry, I'm not talking about that. You also had his mens rea that he's knowingly causing her mental distress.
That's true, and I think that sort of goes to the family member aspect of these DVCPOs in the sense that there is a prior history. He didn't testify, but having been together in an extended relationship, living together, engaged, he's in the best position to know what his words and the manner in which he approaches her, the effect that it would have on her. I think that an individual who spent that much time together would in fact be able to understand that. And to be quite honest with you, the constant ignoring and the constant bombardment, I think it's reasonable to assume that he would know that she didn't want to talk to him, and that the continuing to push him as such would cause problems for her. I don't know how much time I have left.
You have about 3 minutes and 30 seconds left.
I'll just reiterate, I suppose, and summarize that I think all of the elements here have been met. I think that the court appropriately weighed all of the evidence as it came in. I think we have a pattern of conduct. I think there is not only an admission that they are family members, but that the case law supports that designation. It's clear that there is mental distress, as even conceded to by counsel here, that she showed outward crying, trembling while on the stand. It is our position that the trial court was correct and that this panel should uphold that decision and allow the civil protection order to remain in place for its entire duration.
Thank you, Attorney
Thank you.
Bisman. Sorry.
Correct.
And Attorney John, you have 3 minutes.
Thank you. I think it's important, just for one last thing to touch on, is my client's mens rea. Because as stated by counsel, these are two people that had a very long relationship. They lived together. Is his representation that they were engaged, and now what we have is an ending of a relationship, so to say, but without closure or finality. So what is reasonable for my client to, hey, what's going on? What are we doing? And what we have are responses from the petitioner that don't give him an appropriate appraisal of her situation. I don't want you to contact me. You're causing me, without being too legalese in my vernacular, you're causing me mental distress. He is now, opposing counsel wants to put him under an obligation of the effects of his actions, of which he has no knowledge of because his client never informed him. And what we have is multiple communications, all electronic, none face-to-face. This is more than a great opportunity to memorialize a statement back saying, I no longer want to have contact with you. So every time opposing counsel can point to an attempted contact by my client is also an opportunity for his client to inform him of the effect of that, or to inform him of no longer wanting to have contact. But she never did that. So every time they point to his attempted contact, it's a time where their failure impacts the requirement of my client's mens rea and his knowledge of his actions and the impact of his actions. He knows he's contacting her, but he doesn't know the extent of this because she's not in any way communicating to him. Matter of fact, she's sending him communication saying, hey, thanks for talking to me about my tires. Hey, let me send you my condolences about the situation in your family. Both of which don't even indicate a desire for a discontinuation of communication. And again, we're talking about two people that were previously engaged and properly and by counsel's statements had lived together. For those reasons, I think the next analysis needs to be that the mens rea that's necessary for my client was not established at the trial court level. Thank you.
Thank you both of you for your arguments today. The court will take the matter under advisement and issue its decision in due course. The clerk of courts will certainly mail each of you a copy of the court's decision. On the day it's released, you can also check on the Supreme Court of Ohio's website where the opinions are posted. Thank you both again for your arguments.
Thank you, Your Honor.
Hey, judges, real quick.